People v. Bacon.
May it please the court, Samir Degasen for appellant. I'd like to reserve 4 minutes of time for rebuttal.
Yes.
This case involves a conviction that was secured almost exclusively based on identifying information read to the jury by police officers from notes that they made during witness interviews. It is undisputed that those witness interviews occurred several minutes after the officers came to the scene, after the assailant had left, and after the witnesses were moved to a separate location and began receiving medical attention.
Would you like to continue the preservation discussion we were having in the last argument?
Very happy to, Your Honor.
How is this preserved here?
This is preserved because an objection was made that made clear, as the statute requires, the party has to make
The only
its position.
relevant objection I could discern was the objection made at the close of the people's case to dismiss, which discussed at length the sufficiency of the evidence in the case. I don't remember anything about a confrontation clause violation.
So it was framed as a motion to dismiss the indictment, and I think that makes complete sense in this context because it's undisputed, the government has never disputed that if you exclude this evidence that was tainted by the confrontation violation, there's no case left.
Is that argument made if you take away this evidence tainted by the confrontation?
Yes, I think
in terms of a confrontation clause violation?
Yeah, I think if you look at the colloquy, I think it's very clear what counsel is trying to say. And remember, he only found out there's a confrontation clause violation a minute ago. I mean, throughout this entire trial, the government has said, from the opening.
Does it not go instead to legal sufficiency?
I think it's both things. It's this evidence is impermissible, and as a result of that, there's no more evidence, and so the evidence is insufficient. If you look at what he says, so he starts out by saying, this at 567, he says, since we do not have the complainants here, the jury is left with the wrong impression as to the condition of Mrs. Villalando. And he talks about what he would have said to impeach her. So he says, she had taken Klonopin, she was woozy, all of this stuff. This is the kind of stuff I was going to say
And
to
does
impeach
he say anywhere, therefore, you cannot consider any of that testimony because it's a constitutional violation?
Yeah, he says there was no ability to cross-examine. That's at 567. Then he said it's difficult for them to make out a case because they haven't subjected themselves to cross-examination. That's at 570.
It seems to all go to development of the record supporting a conviction, potential conviction.
A cross-examination is obviously the heart of the confrontation, right? In Garcia, the statement, we don't have the witness here, was held to be sufficient to preserve a confrontation clause violation. So saying cross-examination 3 times obviously makes that clear. And I do think, this is only intelligible as an argument that this evidence is impermissible, is tainted by a confrontation clause violation, because he's not saying, look, this evidence is too weak. If you pick this evidence to the jury, a reasonable juror couldn't believe it.
I know,
He's
but we
saying
don't
this
even have to
evidence is-
go there because I think they were pretty clear. The court, I don't know what page it is. The court said the question before the court is based upon the evidence that they did put in, whether it was lousy or not lousy. Is it sufficient to go forward? And at the close of counsel's argument, counsel said, so if your honor is asking me why the people have not made out a prima facie case, that's my argument. And there's nothing about the confrontation clause there.
Well, he's already explained that this evidence that they've relied on is impermissible because he didn't have the ability to cross-examine. And he specifically says
that phrase, I take it, there was no ability to cross-examine, is the crux of what should have alerted the judge that there was a confrontation clause claim here?
Absolutely, Your Honor.
But it's in the context, isn't it, of arguing about sufficiency? It's not clear what would alert the judge that they need to engage that question distinct from the sufficiency.
Well,
Not that one couldn't make the argument, I'm not suggesting that, but what would alert the judge that there's a separate ground here that should be explored?
I don't think they're necessarily separate. I think they're properly intertwined here. He was saying both things. He was saying this evidence, the reason why it's insufficient. He was never saying the reason why it's insufficient is because there just isn't enough evidence here.
I mean, it seems to me that the question whether evidence is sufficient is distinct from whether a discrete piece of evidence is admissible or inadmissible because of a possible confrontation clause concern.
I don't think it's distinct in this context, because no one was ever suggesting that when you look at the evidence, all this evidence, a jury just couldn't believe what these officers are saying. It's too
How about when the
weak. He was-
officers testified? Would that have been an appropriate time to lodge a confrontation clause objection? And that didn't happen here, correct?
No, that wouldn't have been the appropriate time, because there was no confrontation clause.
Well, but there clearly could have been hearsay objections made to all of that testimony,
They
right?
could
when
have
the
been,
officer-
they could have been hearsay objections made, but the
Why?
Supreme
And so what do
Court
we make of the fact that the counsel chose not to make a hearsay objection to the testimony?
says, the Supreme Court said in Crawford, hearsay and confrontation clause are not coextensive. There's lots of things that might not be hearsay, but might still fall within the confrontation clause. And I think it would be reasonable to think this is one of those things, because these could very plausibly be excited utterances. When excited utterance, hearsay exception goes to the state of the condition of the complainants, but that's not what the confrontation clause objection goes to. That goes to the nature of the interrogation, the circumstances surrounding the interrogation. So this, I think, is actually one of those situations where there's a very clear confrontation clause violation, and very plausibly this falls within the excited utterance hearsay objection. So counsel could have been thinking that, and he'd been assured on the first day of trial. The government said, this is at 391, the complainants will explain that all to you. So that was in the government's opening. In our counsel's opening, he says the exact same thing. He says, they're going to talk to you. I'm going to describe what they say, or that they're going to be here in front of you. Then even on the penultimate day of trial, this is at record 451, the government says the only two remaining witnesses will be the victims, who I anticipate calling tomorrow. And then later on in the day, she says, tomorrow I anticipate calling both complaining witnesses, and never corrects that. So he only finds out, the only time he finds out that they're not going to be there and that there is a confrontation clause violation. Until the witness is not made available, there is no confrontation clause violation. He fully expects there to be a confrontation clause
So,
violation.
counsel, I'm looking at the motion, it's around page 567 to 569 of the record, and that, again, that doesn't seem to be what he's saying. It's not that, I don't see anything about it. I realize that a confrontation problem occurred when the victims weren't called. It's about cross-examining one of the victims about Klonopin, and just to really make sure that the court understood what it was dealing with. The court reiterates, and I think you might have heard this in another question, the question before the court is based upon the evidence that they did put in, whether it was lousy or not lousy or whatever, it is sufficient to go forward. And the attorney says, that's right, yes, in the light most favorable to the people, right. And the answer is, by the attorney, no, it's not sufficient to go forward. I don't understand where the confrontation is in that.
It is in so the first part where he talks about cross-examination. I think the issue here is, the government has never disputed that if you take away that the impermissible evidence, it is insufficient. There's nothing wrong with making a sufficiency argument.
That may be true, but we require preservation of constitutional order.
Absolutely, Your Honor. And the only way of understanding this colloquy, and again, he had 2 minutes to think about it, would it have been much better if he had said, what I mean by this is, this evidence is a violation of the confrontation clause, so it should be admitted.
You said he only had 2 minutes to think about it. Are you saying the court didn't give sufficient time for?
No, I'm just saying the reason why it's properly preserved, but the reason it's not completely elegant is he didn't have a lot of time to think about it.
And because during trial, they basically jumped to their feet and they just, it's not an unusual thing for it to be inartful. Is that what you're suggesting?
Exactly, and that's why this court always looks to the substance of what's said and what's conveyed. And I think that's why if you start with what he's saying, it is that this evidence, I should have been able to impeach this person. So that can't be understood as a sufficiency challenge in the sense of,
well, he said I should have been able to cross-examine this person.
Exactly.
And cross-examine them about taking Klonopin.
Exactly.
Yeah, but that's irrelevant if your whole point is what they put on is insufficient. What does it matter what else I would have asked? The whole point is it's sufficient on its face.
What he's saying wouldn't have made sense if what he was saying was, this is just inadequate evidence. What he's saying, the only way of making sense of it is, what he's saying is, I wasn't allowed to present something. So not that this is unpersuasive evidence. The problem is the evidence is too persuasive,
And
because
that's
the jury is
fair.
getting an incomplete picture.
Well, he could be saying both.
He could be saying both, and he was saying both, and it's
It's
appropriate.
insufficient, and I didn't
It's
get to cross-examine.
Correct. It's appropriate to say both. And the last part of this, which I think makes this really clear, is the last sentence of what he says. He says, there's no other witnesses that would be able to testify as to those circumstances, admittedly, other than Alexa Violando. So what he's trying to
Let me
say...
ask you, let's assume for one moment that the court determines that the trial judge only appreciated counsel's statements as a question of sufficiency. Didn't appreciate that it was a confrontation clause argument at all. What does that mean then? Should the rule be that counsel has to clarify that for the judge? I think Judge Halligan was asking a question along those lines. Or is it just, did you preserve it, you raised it? If the judge didn't understand it, doesn't matter, you've preserved your argument.
It's just that you preserved it and raised it, and there's no indication in Garcia that...
But isn't the point of preservation to ensure the judge has an opportunity to address the issue?
Right, it's an objective inquiry, but if you've said enough to preserve something and the judge just isn't understanding it, I don't think that kind of subjective...
I would think that to preserve something, your statement has to be sufficient that a judge would reasonably understand it to make the point.
Absolutely, and in Garcia, it was, we don't have the witness here, and that was
And
enough.
if the court does a sum up, if it says, just so I'm sure, the issue before me is the following, and then says sufficiency, that's still preserved, even though the court it's not that the court misapprehended the argument and counsel had no reason to know it. The court's saying, here I am misapprehending the argument that you are very clearly making, but that's still...
I mean, I guess I don't know if he's misapprehending it in this context, because what is being said is, it is a motion for sufficiency. It's a motion to dismiss the indictment for sufficiency. And what's being said is, this evidence, you can't consider this evidence, Judge, because I couldn't cross-examine them. The jury's going to get the wrong impression. He said the wrong impression multiple times. And then he says at the end, and there's no other evidence that would be able to support this verdict. That's what he's saying. And the judge says, so you're saying it's a sufficiency objection? Yeah, it's a sufficiency objection. I don't think, now, again, it would be more elegant if he said, and don't forget, nested within my sufficiency objection is the idea that this evidence is impermissible. That would be more elegant. But of course, that's what he's saying. I mean, you've got a situation here where, you literally have police testimony of the only two witnesses, the government's entire case. They've been promising these witnesses the whole time. Police testimony read from a complaint report into the record in front of the jury, and then suddenly at the 11th hour, the two witnesses don't appear. Of course the judge understood there's a confrontation clause concern here, and of course, saying cross-examine 3 times should be enough for any reasonable judge to look at that and say, well, I got to kind of think about the confrontation clause here. I think anyone who went to law school would understand that there's some confrontation clause issue here, and I think the judge did understand it. I think what happened here is he just thinks, well, that's not enough for sufficiency, so I'm going to let it go ahead.
Even within 2 minutes, you would have the ability to understand there was a confrontation clause violation, right?
I think so, right? I mean, well, that's, and so that's why you have to look at the whole context of the trial.
So the attorney did appreciate it, he just chose not to use those specific terms.
He used the term cross-examine.
But he went to law school, and he very quickly appreciated the confrontation violation. He just didn't, it was so obvious, he just didn't feel it needed to be mentioned.
I think that might be right, Your Honor. I mean, I do think it might be that
they didn't say that in Garcia either.
He didn't say in Garcia either. And Garcia says, that's how people sometimes talk in the heat of the moment. You say, I couldn't cross-examine him. Here's what I would have said. He's trying to convey the substance of what he's saying. And if you look at the substance of what he's saying, it is not, a jury can't be persuaded by this. No rational juror could look at these officers' testimony and, find in favor of the government. What he's saying is, I have lost the big opportunity here because, the crucible of cross-examination, as Crawford describes it, is all about being able to present impeachment evidence. And he describes the impeachment evidence. He says 3 times, I couldn't cross-examine this person. He says 2 times, it's going to give an incomplete picture to the jury. And then he ends by saying, there are no other witnesses, so there's nothing else, basically. And so, again, it's not the most elegant, but in the kind of substance over form inquiry that this court looks at, I do think it is certainly a lot more than in Garcia. I mean, in Garcia, the government's argument was, well, you can't tell the difference between that and a hearsay objection, and this court said it's still enough to preserve a confrontation clause objection. So this seems a lot, at least to my mind, the substance of this conveys a lot more information about what kind of thing he was asking for than the objection in Garcia. And I do think that timing, I mean, the government sort of jumps between the sort of form and the timing objections. I think the form objection, again, it just, was he able to understand it? I think absolutely it was clear that he was. And then we cite the State versus Corbado case on timing, which is that the violation is not complete until that moment. So I think all the timing issues fall out of this case as well. It's just, was this intelligible? Was the judge on notice? And I think the judge, was pretty clearly on notice based on the full colloquy and the substance and the full context.
Thank you.
Thank you. So on to the...
Well, your time is up, but if you would like a minute to go on to that and then deal with the rest of your rebuttal, that's fine.
Great, thank you, Your Honor. Well, so I think the merits of this are straightforward, as I was describing. I mean, the emergency exception is limited to situations that are a cry for help or the provision of information enabling officers to immediately end a threatening situation. We're of no case from the U.S. Supreme Court that has found the emergency exception satisfied when the questioning is not immediate. You know, all the cases where the emergency exception occurs in Bryant, in Bradley, in Andino, it is immediate. We're aware of no case where the exception is being satisfied when an officer is taking notes of the witness testimony, and this case has both, and so I think it falls within the heartland of testimonial statements barred by the Confrontation Clause. And the First Department's rule, if this court allows that rule to go into effect, and it is the rule that the First Department regularly now routinely imposes in this kind of emergency exception case, is basically that if the perpetrator is still at large and the victim is visibly shaken, that's an emergency. That satisfies the emergency exception. That is a test that has no manageable limits. It works a radical expansion of the exception.
Why is it an emergency if they see the alleged perpetrator running in the tunnels to potentially another station?
I think it might, you could characterize that as emergency, but as the Supreme Court said in Bryant, the existence vel non of an ongoing emergency is not the touchstone of the testimonial inquiry. Instead, the ultimate inquiry is whether the primary purpose of the interrogation, so it's the interrogation, was to enable police assistance to meet the ongoing emergency. So, of course, in all situations where there's been a violent crime and the perpetrator is on the loose, you could characterize that as an emergency or a dangerous situation. But you then look at the circumstance of the interrogation. And here, there was a conversation that we fully admit could have been non-testimonial, which is when, as soon as the officers come down, they say a bunch of stuff, he hit me in the face, we've conceded down the line. That's non-testimonial. But when you take the person upstairs, you wait several minutes, you wait for medical attention to arrive, you take out your notepad and you start writing it down. There is no case that they cite that looks remotely like that. That is quintessentially testimonial. As the Supreme Court said in Davis, we do not think it's conceivable the protections of the Confrontation Clause can readily be evaded by having a note-taking policeman recite the unsworn testimony of the declarant. That's exactly what happened here.
Am I correct that it was at that subsequent outside upstairs questioning that the police learned that there were actually two people involved in the commission of this crime?
I think they may have mentioned there were two or downstairs. I'm not 100% sure. I can check for rebuttal.
No, I'm just wondering, that would be something that, seems fairly non-testimonial and more like they're still investigating an ongoing emergency, which was, and my next question, and you can answer one or both or neither. Can't sometimes it be both? Can it be both investigatory and maybe?
Right, it almost always is both. That's the sort of nature of these things. It is dual purpose. And so then you have to look at what the primary purpose is, and you basically ask the question, what would a reasonable observer, what would they think the primary purpose of this is? And I think in a situation where, if you ask the question immediately, like in Bryant, you have a potential active shooter situation, what's happening, where is he? That is a sort of thing that a reasonable observer would look at and say, and just, like it was on the subway platform, where did he go? They went and looked and all of that. Those kinds of questions, those fit comfortably with the emergency exception. But I don't think a reasonable person thinks, well, when you take you take an individual above ground, you wait several minutes, you take out your notepad, you start writing, even if, in the officer's mind, it's like, well, this will help us resolve the crime, maybe we'll catch him. But,
or maybe help us find the
maybe,
person.
that could be a purpose, but it's not the primary purpose at that point, because at that point, when you're noting things down, you've waited all of this time, the primary purpose is to create a record for the investigation. And this case is, I think, unusual because the actual testimony here really reflects that what they were doing was exactly that, was making the complaint report. The government suggests in their brief that we don't know if they were really making the complaint report. That's not true. If you look at the testimony at page 407, this is the question. What do you do when the suspect is no longer in the scene? Answer, we try to get a detailed description of the suspect and we put the information down on a complaint report. Then the next page at 408, it then gets entered into a computer. And then 10 pages later at 418, they are asked the question, after the complainant's meeting with the EMT, what did you do? Answer, we asked her questions in regard to what happened and we took a report. We asked detailed descriptions of the
That's
suspects.
logical, is it not? I mean, you're not going to get that kind of information and never archive it. That's all that's saying. We got the information, and we eventually put it in a report.
It was saying, what's your routine practice? That was at 408. Your routine practice is, after you know the assailant has gone, you sit down and you start taking detailed information to make a report, and then we enter into a computer. That's what he says. And then later on he says, so what did you do in this case? And he said, we, quote, took a report and we asked detailed questions. So this record is very clear that what was happening here was they were asking questions at that point for the purpose, they were following their routine practice that they described on the stand. And then the reason why there's so many, there's a long colloquy about the complaint report at 423 and 24. Why? Because the prosecutor is laying the foundation for the use of the complaint report as the notes to refresh the recollection. So various times then, they take the complaint report out and the memo book that was made on that day, and that's the basis of the testimony. So it is quintessentially the kind of testimonial statement that we saw in Crawford. And they don't dispute that these statements were later used for the complaint report. They don't identify any other interview that was used for the complaint report, and no one has even testified to any other purpose of these statements other than creating the complaint report. So it is about as clear as day that this was a situation where they were taking these statements down for investigative purposes, for purposes of the complaint report.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Julia Gorski for the People. Defendant never objected on Confrontation Clause grounds. While he complained about not being able to cross-examine the victims, his complaint was made within a routine trial order for a dismissal, where the question...
So why isn't that enough?
Because the question under that specific motion is whether or not the people's evidence, as is legally sufficient, not whether the people's evidence is still admissible despite the victims not appearing in court.
So why isn't the reference to cross-examination sufficient?
Because it did not alert the trial court to the detective's testimony that they are now taking issue with on appeal.
Well, what's the point of even mentioning cross-examination, if not to raise for the court that there's a confrontation problem?
Well, they were not arguing that without being able to cross-examine the victims that their testimony was now inadmissible. They were saying we wanted to bring out more testimony to show that their testimony was actually unreliable. That is legal sufficiency.
Well, do they have to go through some explanation as to why they're asserting 3 times, apparently, that they were not able to cross-examine? Do they have to explain that to the court?
Yes, they had to make a confrontation violation because it needs to, the trial court needed an opportunity to address this issue.
So what is the difference between saying I can't cross-examine the witness and saying the witness isn't here?
Well, in the context of a legal sufficiency argument, that's not even the proper remedy. The proper remedy is not even dismissal of the entire indictment.
No, but that does get you preservation of confrontation, because that's what was said in Garcia.
No, and the biggest distinction in Garcia is that the defendant moved to strike the detective's testimony because they were not able to cross-examine.
In this particular instance, when neither of the claimed victims are present, isn't it obvious that confrontation is an issue in context of the arguments that the defendant was making?
Well, no, and there's 2 things there. First, the
Why?
defendant never objected contemporaneously on hearsay or any other basis. So he took no issue with the statements coming in as excited utterances. And second, to solidify that he took no issue.
How do we know that's the reason? That is, isn't it possible that he took no issue because he believed he would be able to cross-examine these witnesses?
Well, yes, and when he learned that he would not be able to do so, he did not make a motion to strike the detective's testimony, and he did not move for a mistrial. And I think what really solidifies that this is not what he was talking about was that in response to his legal sufficiency argument.
So because he asked for what you consider an inadequate remedy, he didn't preserve the constitutional claim?
I think it supports that he was not making a constitutional claim. And additionally, in response to his
Well, on
legal
the sufficiency, I just don't see the point of saying I didn't get to cross-examine. What does that have to do with the sufficiency?
it went to the credibility and the reliability.
And confrontation is about the credibility and being able to test. That's all that SCOTUS tells us. That's the
Well-
jurisprudence, being able to test through cross-examination the credibility and the witness's testimony.
Correct, but he took no issue with the testimony that was already in evidence. He never drew the court's
Well, he
attention
must
to
have
the
that-
detective's testimony.
But the objection, I haven't had the chance to cross-examine, isn't that challenging the testimony that came in?
Not necessarily, especially not in the context of a legal sufficiency motion. Maybe in a motion to strike testimony or a motion for a mistrial, but not in this context.
Why do you say that?
Because the issue in legal sufficiency is whether or not the people's evidence established every element of the charged crime.
Right, and
You
if you
view that
say-
in the light most favorable to the people, so
Right,
you're
and if-
taking.
Right, and if you say, in the context of legal sufficiency, I haven't had the chance to cross-examine these people, right?
Correct.
Aren't you necessarily saying, and therefore you can't consider that testimony?
I don't think so. I think you're just saying, I would have liked to bring out more testimony in addition to what has already been brought out. And I think it's very important that
Could you be saying both?
I think that's a stretch. I think that is a stretch in this context. And the prosecutor, in response, said, even though the victims did not testify, their testimony is in evidence as fact. She repeatedly said that in response to
But
the motion to dismiss.
Why would if you say, I would just have liked to bring out more testimony, why would that go to legal insufficiency?
It didn't, and that's why the court had
So
to
then it has
redirect
to be,
him.
but then it has to be understood as going to confrontation.
No, it doesn't, and the court didn't understand it that way either. And
What is he trying to communicate, if not a confrontation clause concern with that statement?
he is communicating that without the victim's live testimony, the people could not establish every element of the charged crimes. He's saying that the testimony that came in through the police officers was not enough, that the victims needed to be there, and I believe in the course of his motion, he says that Violando was the only person that could testify to certain elements of the charged
Well,
crimes.
he's surely not saying the more testimony that I would like to bring out through cross-examination is testimony that would make this legally sufficient.
Right.
I'm sorry, I don't think I understood your question.
Sure. It seems to me you were saying the way to understand his complaint about lack of cross-examination is that he would have brought out more testimony on cross-examination, right? That's the first thing you said, I think.
Well, yes,
Okay.
he's
And
not.
so it can't be the case that the more testimony that he wants to bring out is testimony that would make the case legally sufficient.
Yes,
Right.
he's saying, well, true. I think he was a little confused between weight of the evidence and legal sufficiency, and that's why the judge said, but the issue is taking the people's evidence, however lousy or not lousy it is.
He can't, I don't think, be understood to be saying there's a sufficiency problem and I would like to, I'm complaining because I didn't have the opportunity to elicit even more evidence. That doesn't seem logically.
I want to
Makes
elicit
sense.
more evidence for purposes of making the people's case against my
Yes.
client.
Yes.
That's correct. He wanted to elicit that the
how
victims
could
were
that
not
be?
credible.
To undermine the people's case, that's on the confrontation side. That's not to establish the sufficiency of the people's case. He's not trying to make the people's case against his
Well,
client.
right, he's trying to disprove it. He's saying it can't go forward.
Counsel,
saying
is there
it's not-
anything in the record to indicate that there was some confusion over sufficiency and weight of the evidence review?
The judge said that the issue before me is whether the people's evidence, in the light most favorable to the people, is sufficient. And they asked, is it sufficient? And he said no, and he went on to state that the only person that can testify to these certain elements was the victim. And as one of your honors had mentioned, he says, if you're asking me whether or not this is legally sufficient, my answer is no. And then
Right,
he
in response to
proceeded.
that direct question, that's not a question about the confrontation clause. But let me ask you the same question I asked your friend on the other side here. Let's assume for one moment that we conclude that the judge did not appreciate that this was a confrontation clause argument, but that it was preserved under our jurisprudence. Why don't they get the benefit of that?
Because
Does the judge have to understand in order for the preservation bar to be addressed?
Well, I don't think it's fair to make the assumptions that they are making on the existing record when the record was not developed to ascertain whether or not there was an ongoing emergency when the officers arrived on the sidewalk. It's a record issue. But even assuming
No, I'm
that
talking
this-
about the preservation question.
Yes, even assuming that this is
Let me put it
preserved.
another way. Do we resolve preservation questions? That is whether or not the party who's arguing they've preserved has sufficiently preserved by looking to see whether or not the judge understood their argument.
No, it's whether or not they made an argument sufficient to put the court on notice of the exact argument that they are going
Whether or not the judge figured it out, you say that's not relevant to that analysis. On the preservation, just on the preservation.
Yes, it's the defendant's burden to
Fair
preserve and make the court known.
So if we look at page 567, right, the first statement that seems relevant to me from defense counsel is, in addition to that, since we don't have the complainants, the people have rested without the complaints, and the jury is left with a wrong impression as to the physical and mental condition of Alexa Violando at the time of the incident. So if defense counsel is arguing that the evidence that is before the jury is insufficient, why would counsel say the jury is left with a wrong impression? That doesn't seem to me to logically bear on what defense counsel would have to be arguing, which is the evidence that's already in is insufficient.
The defense attorney needed to draw the court's attention to the police officer's testimony that they are challenging on appeal. Nothing that he said there was adequate to draw the court's attention to the
But
specific
what could he have
issue.
meant by saying the jury is left with a wrong impression?
Because he wanted to elicit that she had a drug issue and maybe became.
Yeah, but the point is that he wasn't able to. And so the testimony that he might have elicited about those conditions was not something he was able to elicit, right? So why is telling a court, gosh, if the witness had been here, I would have put in evidence that would make this even more insufficient? I can't understand how defense counsel could mean to communicate that. Now, maybe the references to confrontation are slim or perhaps lacking, whatever, but I just don't see how you make sense of that statement or the statement there's no ability to cross-examine.
Just because it was in the context of a legal sufficiency motion, and the standard is much different than if he was moving
How
to
do
strike
those
the testimony.
particular statements bear on sufficiency from the defense counsel's perspective? Why as defense counsel would you say that if you are arguing insufficiency?
Because he was saying that you needed the victim's live testimony to establish every element of the crime. That's legal sufficiency. He had a perfect opportunity to clarify his position when the prosecutor repeatedly said that even though the victims did not testify, their testimony to the officer's testimony as to their statements was in evidence as fact. She repeatedly stated that, and the defendant took no objection or any challenge to that statement.
And what do you say with respect to, if we got to the merits, as to the exception of an ongoing emergency?
Yes, the victim's statements here were not testimonial. Defendant's argument evaluates whether there was an ongoing emergency in hindsight. When the officers found the victims on the platform, they had no reason to believe that the emergency was limited to just them. There were 4 911 calls for an assault in progress. It was bystanders on the sidewalk who directed them onto the platform. On the platform, they see 2 bloody and hysterical victims, and they have no indication that this was a private dispute, and they have no indication of how these victims sustained their injuries. They also see the defendant running down the subway tracks. In addition to not knowing what risk he posed to people at the next station, he's now at risk of being struck by a train or electrocuted. Given all of this uncertainty, The officers testified that they were focused on getting the victim's medical attention, getting more information, and locating the person that was on the tracks.
So when you say that, locating the person that was on the tracks, there is no evidence that they used that information and radioed it forward to anybody else to try to get him at another station. So, or can you point me to any evidence that shows that
Well,
was what they were doing to confront this ongoing emergency?
There's no explicit evidence, again, because the parties never litigated below whether or not this was an ongoing emergency. But we do know that additional officers were called to the scene. All train traffic in the area was stopped, the power to the tracks was shut off, and a sweep of the tunnels was conducted to locate the defendant.
And did this information that was derived regarding the description, all of that, was that communicated? Is that in the record, that it was communicated
I
to
think-
all these additional officers?
I think a good inference can be made that it was, because, and again, they didn't have this information until they spoke to the victims on the sidewalk. When they spoke to the victims on the sidewalk, that's when they learned that there were 2 assailants, and they got the description of both of those assailants.
And when was the defendant arrested?
I believe a month later.
And how did that information come out? And when?
The detective, there was a detective assigned to this case. He met with the victims on a few occasions, and I believe one of those was a few hours after the incident. And I think.
So how about like immediately after the incident? Was there any information about the person's name or what he looked like or descriptions? Or did that have to wait until the detectives got involved?
Well, immediately after is on the sidewalk. It's these statements that were at issue. And
Immediately after.
it is immediately after.
Isn't it several
within
minutes, they
moments.
leave the platform, they come up?
Yes, and
Yes.
they officers testified that they took the victims upstairs specifically to get medical treatment and more information. I don't think.
And
the-
they did get names during that upper part questioning, didn't they?
They got nicknames, so
They
they
got
did.
Zebo, I think, and they got Carlos, which is actually not a nickname. Carlos is
Yeah,
actually Carlos.
well, not full names and addresses as they did.
No,
in
but I'm
Michigan
saying
versus
they
Bryant.
got some identifying information,
Yes.
right? So,
Yes, and I believe that that was relevant to the officers conducting a sweep of the tunnels because they needed to know,
How would knowing Zebo and Carlos help you find the person?
well, if they
If
find.
in the moment, as an emergency, in the tunnel going to the next station, how does knowing Zebo and Carlos help
Well,
you?
maybe not necessarily the names, but their descriptions. Their descriptions are certainly helpful.
What were the descriptions?
I believe they gave the color shirt and pants that they were wearing, their skin tone. I'm not sure on the exact specifics. But contrary to the defense argument, I do not believe the record supports, and I know my time is up, just very quickly. I don't believe the record supports that these statements were elicited after the victims were treated by the EMTs. We know that after the EMTs treated the victims, they were not discharged at the scene. They were brought to the hospital. And there are a few times in the officer's testimony, it's actually right after the point where they say, after they were meeting with the EMTs, we took a report. Immediately following that, the officer had brought out the fact that he needed a description of the assailants. And the prosecutor takes the officer back a step and says,
So let me ask you this, what's your rule? Sort of, where's the limiting principle? At what point in time would gathering information be so distant from the urgency of the emergency that we can say that it's no longer an emergency?
when the officers have enough information to be able to assess the situation unfolding in front of them. If their primary purpose is to get that basic level of information of what we need to do right now to solve this situation, those statements elicited are non-testimonial. If the officers go beyond that, they figure out, okay, nothing else needs to be done here, this was a private dispute, no one else is in danger, then I think the conversation will likely switch over to
So
testimonial.
they asked, how do you know them?
I'm sorry, can you?
If they asked, how do you know them?
It's hard to say specific questions. It's the entirety of the circumstances.
it sounds a little bit to me like you were about to say before that because the ambulance was coming and they weren't discharged at the scene, that they went to the hospital. This was the officer's, I guess, last opportunity to get actionable information at the scene before they were taken away to the hospital. Is that the implication of your argument, or is it something different?
Well, no, I don't know if that's necessarily the case, that they were trying to gather as much information as possible before the victims left the scene. I think their testimony negates the argument that this conversation occurred after medical treatment as opposed to before and
Oh,
during.
so you're just saying the timing is not what you might,
Correct. It was not, 30 minutes, an hour, 2 hours later after the victims are discharged from the hospital.
And if it was after medical
immediately.
treatment, is that then fall outside your rule? So then it wouldn't be within the emergency exception?
Well, I think a good contrast is the detectives at the hospital, right? Because now this has been several hours after the incident. They're much farther away from the crime scene. And the detectives, being detectives, it's their job to investigate. These are not the first responders trying to figure out what action needs to be taken next.
Although if these are dangerous individuals and they're still on the loose, I thought you'd argue it's still an emergency.
Well, the Supreme Court has held that it's not going to be an ongoing emergency so long as this individual is unapprehended. It's a totality of the circumstances. So again, how long after the crime scene is this a secure location? What is the purpose of their interrogation? And as a detective, when you know that the responding officers got enough information to be able to take next steps, now you're coming in as a secondary and trying to nail down.
But was he correct, if I understood him? If I'm wrong, he'll correct me, that the testimony from the officer took the information and then put it in a report?
I think the officer was speaking very generally about the fact that when there is no longer a suspect on the scene.
One would be surprised that if really you did pass that on to others because you're in the middle of an emergency, that you somehow forgot to say that during the testimony.
I don't think so, because the testimony was just setting up in general how a case ends up in a detective's hands.
Did they ever say it was an emergency?
They did not explicitly state that they were responding to an emergency, but they did state that their reasoning for bringing the victims up onto the sidewalk was to get them prompt medical treatment, more information, and to be able to locate the person that they saw on the tracks.
And was the report that was used at the scene the one that was used to refresh the officer's testimony at trial?
It was used to refresh his recollection. It was not admitted into evidence. It was not marked for identification. The officer never testified when exactly he filled it out, whether he filled it out as he was speaking to the victims. He used it within a bunch of the police paperwork because it was his job to complete all of that day's paperwork. So it not only included the complaint report, but the record also shows it included memo books and aided cards.
does that usually happen? Does paperwork, like a DD-5 or something like that, get filled out at the scene?
I'm sure it depends on each situation, but here the officer responded that after the victims were transported to the hospital, as the recording officer, he had no other responsibility besides to complete paperwork, which he noted would include
There was
the
no
complaint
testimony, or correct me if I'm wrong, it doesn't seem that there was any testimony in the record about what he was writing when he was collecting information at the scene. Like, it could have been the memo book, but it could have been something else, right?
There was no testimony at all that he was writing anything down.
Oh. So we know nothing about, so the part about refreshing the recollection, we don't know when that was created at all?
No, but as I was saying, I think the best inference to make based on his testimony is that he had completed it after the victims had been
He didn't
transported.
testify he's taking notes?
No, he testified that all of the testimony came out as the officer was refreshing his recollection with his notes, but he did not testify that he was actively taking notes at the scene. And if your honors have no further questions, I rest on the brief. Thank you.
Thank you, Your Honor. I think that it was interesting to hear that the limiting principle that we heard of for the emergency exception was, as far as I can understand it, was that the person has to already be transported to the hospital. So that, I think, underscores just sort of how frighteningly broad the way in which the government is interpreting the emergency exception here. And I think what that will mean in practice is that in any case, it would make sense for the government simply to, take information into a complaint report and then have your officers read that information into the record. Because, of course, this was a witness who had maybe drug problems, was falling asleep during the interrogation. There was all kinds of stuff that was very impeachable. This was a witness that wasn't going to be very credible. And a prosecutor is always going to make the decision that it makes a lot more sense to not produce that witness for trial and rather have an officer read that information into the record.
So what would you propose as the correct limiting principle for the emergency exception?
I think it's the one that the Supreme Court has articulated in Bryant, which is that does a reasonable observer looking at all of the factors think that the primary purpose is investigatory? And I think the factors, as we specified in our brief, like the timing, the amount of time, like the movement from one place to another, and the note-taking, and we've cited multiple places in our...
You would have to concede, wouldn't you, that there could be a rather extended period where the primary purpose is not investigatory, where it's dealing with an ongoing emergency?
Absolutely. And as the Supreme Court said, frequently these situations evolve from one thing to another.
Yes, they change, but they can be emergency for, for whatever reason, I'm thinking about the person who was accused of shooting the CEO of United Healthcare. That emergency seemed to go on from where I was sitting for days.
Right.
They were looking for someone, and everyone was afraid that people were getting shot in the streets. So I'm just saying, there are circumstances where the emergency is not abbreviated.
Correct, Jared. And that's exactly why the presence of an emergency, the fact there's an emergency happening, vel non, is not the test. The test is, what is the interrogation about? So absolutely, there can be an emergency going on, and one would think that's an emergency. But you look at the circumstance of the interrogation, and you think, this is the thing, is it a cry for help? That's a narrow exception. This is a cry for help, or it's something that will allow the officer to immediately end the threatening situation. And this is not one of those things, because if you wait the amount of time that they wait, and below, they note that there was potentially 14 to 20 minutes from the time the officers arrived. That's at page 35 of their brief below. That's what they said was the amount of time. If you wait that amount of time, take them to a new place, and you start taking notes. We cite places in the record where they do take notes. They specifically says he was taking a report. They've never disputed until right here at oral argument that he was taking notes at the time. So all of those things are factors that you consider.
But when they get down to the platform, again, as I mentioned before, they do see someone running in that tunnel. So they're still close in time to the alleged perpetrator being nearby.
And we've never disputed that those statements are non-testimonial. So the stuff that was said down there was non-testimonial. This is almost like going back to my law school, this is like almost a 1L issue spotter, You've got these non-testimonial statements.
But my point about that is about the timing, because you said all this time had passed, but the reality is when they arrive, it appears that the perpetrator is still there, or still nearby.
They arrive in a few minutes, so I think it's that the 911 call is at 3:18, they arrive by 3:25, the perpetrator is still there, but then in the brief below, they say there's another 14 to 20 minutes, and the relevant statements, the ones where they go above ground, medical attention comes, they're waiting all this time, no reasonable person thinks, oh, yeah, there's an ongoing emergency, something really dramatic is happening right now, and you wait 14 to 20 minutes, that's not
she
normal.
disputes, I think, this timeline that you're now arguing about when the medical attention was provided and when the questioning was conducted.
Well, so for their brief below, and they've never suggested otherwise, is that the questioning only begins after medical attention begins. That's at 3:32. Even if it's 3:32, that's still 7 minutes from when the officers arrive. In their brief below, they said 14 to 20 minutes. They've now gone back on that. And then the only testimony about timing is, the question is after, after the EMTs arrive, well, what did you say? And so it seems like it has to at least be after 3:22. So the timeline, the key point about it, though, isn't 14 versus 7. It was not immediate. It wasn't the stuff on the subway platform. It was the stuff above ground after they moved location and after they started taking notes. I just have a couple of things to say on remedy, on waiver, but I'm happy to rest if you guys.
Can you just quickly address this issue raised again by your friend on the other side, that it was a motion based on insufficiency, whether or not, as I asked her, does it matter that the relief requested may not have been adequate or appropriate to a confrontation clause claim?
No, because I think just as with the substance of, you don't have to say confrontation clause, in the same way you don't necessarily have to say motion for exclusion. If you say motion for sufficiency and then the substance of it is it's insufficient because this evidence is stuff that I should have been able to cross-examine, as I think the colloquy you heard with the other side explains. There's no way of understanding the substance of what he was saying as anything other than I was deprived of my ability to impeach this person. The jury is now going to get the wrong impression, and that's the sense in which it's insufficient. It's insufficient because you got to subtract the impermissible stuff, not that the impermissible stuff, without my impeachment is not persuasive and the jury couldn't possibly believe it.
But isn't the way to subtract the impermissible stuff to strike it?
Yeah, and that is, I think what he's saying is, that's kind of what has to happen here. You've got to disregard it, Judge, because that's impermissible. So don't look at that anymore.
So it's a motion. It's a motion to strike the testimony of the witness by implication.
No, it's a motion for sufficiency. He's saying that evidence is all a confrontation clause violation. So that can't come in to the jury's thinking. And when you look at the rest of it, it's insufficient.
There is a colloquy after he says, I didn't have a chance to cross, and the judge says, it doesn't matter if the evidence is lousy or not. He says, the judge says, is it sufficient? It's not whether it's lousy or not. Anything further on that? And the defense counsel says, okay. So I tend to agree there were photos, and he's talking about all the things that are in, and the police officers say her nose was bleeding, from whom, who hit her. It's very difficult for the people to make out a case when the complaining witnesses do not come to testify. That's an incomplete picture. And in the flow of that colloquy, after the judge says, it's not evidence that's lousy or not lousy, it's they get every inference, what do you got? The defense counsel starts laying out, well, here's what's there.
Yeah.
I mean, at that point, it seems pretty obvious that the defense counsel's making on this record, it's just not sufficient. Not you have to take this part out, and then it's not
He's saying
sufficient.
both things. I think it's exactly. He's saying, look, this is the evidence. There's not much evidence. Look, there's not much evidence. And then he goes back and says, it's very difficult to make out a case without a complaining witness. It's going to give a, quote, incomplete picture.
But it's
and then
not, he goes back. It's all part of that one statement to the court about why this record isn't lousy. It's, why, if you accept it and you give every inference, it's not enough.
Well, no, because he says, I think it's going to give an incomplete picture, and he's saying because he can't cross-examine that person. So that's the part that I'm not saying it's not a little jumbled. Obviously, but we don't, this is why it's substance over form. These are, defense attorneys have lots of cases. These are high-pressure situations. Sometimes they don't speak with perfect clarity. Waiver is an incredibly harsh remedy, as this court has recognized. And in Garcia, it was far less.
Though, it's preservation, right? So if the judge is saying, basically indicating, here's how I'm taking what you're saying. It's not lousy or not lousy. It's this standard. What have you got?
But it makes sense in context, because what he's saying is, look, there's all this other evidence is insufficient, and then when he discusses the government's evidence, the witnesses, what he's saying about them is not, those guys just weren't credible. I mean, if he'd said that, if he'd said, no one could possibly believe that wasn't credible. He never says that. What he says is, I should have had the chance to impeach them. I should have had the chance to bring Violanda in and elicit more testimony. And so that's where the government's case is breaking down, because they're relying so much on this thing, and I never had an opportunity. And I think the government's theory in this case is basically, if he said a whole heck of a lot less, maybe he would have been able to preserve it, but because Garcia is a whole heck of a lot less. They say that Garcia...
But you keep comparing that and saying it's a whole lot less, it's a whole lot more. And to me, it seems like you look at what is the context, what was said. So it may be less in one situation where the context is clear, and it may be more in where it's totally confusing and you can't make out what the objection is. So I have a hard time following that. In Garcia they said X, so that's enough. Garcia's a motion to strike, so maybe X is enough there. Here we have a colloquy on sufficiency. What's enough to raise this particular issue here? Yeah,
and I think it's, as the government argued in Garcia, it's not clear when we don't have the witness here exactly what that's referring to. This court said it was enough. They described, they said, the key thing is that in the charge conference, he then reiterated again that objection. That's not true. In Garcia, at the charge conference, he made a hearsay objection. And that, if you go to look at the record in Garcia, we looked this up, at A20 to 20, at A120 to
But I think the
121.
point, counsel, is, that I'm just trying to make here with you is, it really depends on what is the context of the back and forth, the colloquy with the court.
100%.
And what are the words that have been used. So it's very hard to import specific language from one and say, well, that was enough here, it's enough here. I take your point that that was enough in that context, and it could be interpreted various ways. But I think what we're left with here is what was actually said, and how can that reasonably be interpreted by a judge.
I don't disagree with any of that. I think what Garcia reflects is that we don't elevate form over substance, that we do, that this court is, appreciates that sometimes objections are not made in exactly the most perfect way, but I completely agree. You have to look at the substance of the colloquy. And I think after being here for 40 minutes, I think the key thing is you look at the substance of that colloquy. It is impossible to understand how that makes sense as a sufficiency objection in the way the government is describing it. It doesn't make any sense as a sufficiency objection in that way. It only makes sense as a confrontation clause objection, and that should be enough. And
Thank you.
Thank you. Well, I have one last thing, which is if the court has any questions on the juror issue, I'm happy to answer them just to give you the opportunity to ask questions, but I'm not going to force you to stay. Thank you.
40 minutes.